Okay.
Well, good afternoon. My name is Ala McCoy. I am Director of Startup Support at University of Maryland's UM Ventures. And I would like to extend a warm welcome to all of you who joined us today for the next installment in Startup Fundamentals Workshop Series, both live webinar audience and those watching a recorded version on our Startup UMD YouTube channel. This workshop series is offered in partnership with Maryland Technology Enterprise Institute, or MTech, at the Clark School of Engineering. To everyone attending the live session, please feel free to submit questions using the Q&A function. You should be able to find that at the bottom of your screen. We are recording the session. It will be on YouTube. So if you would like to remain anonymous, you can choose that option. There's a way to click an option to remain anonymous. Also, at the end of the session, I will be able to unmute you. You will be able to click the button that says raise my hand, so you can raise your hand and I will unmute you. You can ask your question that way. But again, remember that this is going to be on YouTube. Today I am very pleased to welcome as our speaker Mark Ehrmann. He is a highly experienced startup and emerging company attorney. He's a corporate lawyer who advises early stage and maturing companies. So thank you so much, Mark. I'm not gonna read the rest of your bio. I'll let you introduce yourself, as you will do it so much better than I. Thank you so much for sharing your time with us. It's such an important topic from the very get-go to make sure that that your company is set up in the right way. So thank you so much for sharing your knowledge with us. The mic is all yours.
Okay. Thank you, Ala. As she mentioned, my name is Mark Ehrmann. I'm a partner with the law firm Quarles Brady. For those of you who don't know about Quarles, we're a large national firm. We have 13 offices spread across 10 states and the District of Columbia. And we're a full service law firm. By that, I mean we practice in a lot of different areas. I work in our business law group, which means I focus on business law issues. And specifically, part of my practice involves working with in the emerging company space for emerging companies themselves. Sometimes it's acting as counsel to research institutions like Maryland or others. And then sometimes it's also talking with investors and working with them. What I hope today to do is, first of all, I wanted to welcome you and thanks for joining me. It's a little difficult just talking to a computer screen. I wish I was doing this in person because I could take questions sort of live, but I'm going to talk for about 40 minutes and try to cover some basic things that come up when you're thinking about starting a company. When you go to start a company, it can be very daunting, and I'm trying to make it a little bit easier to understand, and happy to answer questions then after I'm done with my remarks. So if we go to the first slide, first question we get asked is, well, sometimes it's, do I even need to start a company? Can I just do this without starting a company? And the answer to that is generally, that's not a good idea. The reason you want to have an entity is because the entity gives you liability protection. So you can make sure that any assets, any liabilities associated with the business are kept in the business and not mingled with your personal assets. So deciding to use an entity is typically the choice that people make. And you really have two options. You either have C corporations or LLCs. There are other types of entities that people have used, partnerships, S corporations. Those really don't work well in the startup space, so I really won't address those. C corporations, LLCs are similar, but they do have some differences. The main difference is that LLCs, if they're taxed as a partnership, which most are, you don't have two levels of tax. By that I mean you don't have an entity tax that the entity pays when it has income, and then a separate tax that you pay when it's passed through to the shareholders. Now, for startups, that doesn't really make a big difference because most of them don't have tax up front. So I would say more than half of the companies we work with decide to use the C corporation status, which is the basic corporation that most people are familiar with. It does give you the same liability protection. Both entities are easy to form in the sense that you just file articles of organization with the state, and then you can move forward. The one thing that is interesting is that if you're going to use outside investors, like venture funds or other entities that invest, they'll likely want to have you become a C corporation. So even if you start out as an LLC, you'll likely have to convert to a C corporation. It's relatively simple to convert from an LLC to a C corporation, less less easy to go the other way. So if you think you might have outside investors, typically people just choose to go the C corporation route to start with. So if you go to the next slide, please. So then the question is, where do I set that up? You have to choose a state to be headquartered. Delaware, as many people know, is the most common one. And that's partly because Delaware has years ago developed a very good corporate law, which people like using. They also have a separate court of chancery, which is like their business court, which is different than kind of the general court. So people like using Delaware. Now, Delaware's come under fire relatively recently. Elon Musk and others have said that they want to move away from Delaware because they don't like some of the way the judges are interpreting the laws there. But Delaware is still by far the most popular jurisdiction. And you create your company by filing articles of organization. Once you file those, you're in existence. Other people oftentimes choose their home jurisdiction. By that I mean, if you're located and you live in Maryland, you'll choose Maryland as an entity. Outside investors, they typically like using Delaware just because they're more familiar with that. That's not really one thing that they're going to get real hung up on. But if you use Delaware upfront, you'll typically avoid some questions down the road. Now, once you get your company set up, the next step is typically to get a tax ID number. Now, what that is think of it as like a social security number for your entity, because you want to have that separated so that you're a separate taxpayer under the IRS rules. And you need that tax ID number to open a bank account. Banks will require that typically for you to open an account. You can get a tax ID number over the phone. At least you could, assuming that the IRS still has agents left after the recent cut. But you can typically do it over the phone. We can help on that. And you typically need to fill out a form and answer some questions. And you will need to provide your own social security number or another individual's social security number in order to get that over the phone. So if you go to the next slide, please. So that's kind of a real brief background of sort of the basis of getting your entity established. But that's really just the first part of what you need when you have a company. This next slide goes through a series of agreements that we typically deal with founders on. And I'll cover each one in some detail, but I kind of listed them in the order of when they come up when we talk to people. Now, you don't need these all up front. People look at this list and go, oh my gosh, that's too many. Yeah, I can't even put my arms around that. We typically kind of go down this list, and as the company gets more mature and more stabilized, we'll go in, from agreement to agreement. But the first part of that, you've moved to the next slide, please, is the founders agreement. What that is, if it's a corporation, it's a shareholders agreement. If it's an operating agreement, it's an LLC. It's an operating agreement for limited liability companies. And what that is that's the basic agreement that is among the people that decide to set up the company. So when you think about it, if you have three partners going to set up a company, we oftentimes hear people say, well, I don't really need an agreement. We're friends, we're family members, we'll just work it out. That sounds good in theory, but our experience has been, if there is a problem or an issue that comes up later, it's good to have an agreement in place so that you understand where everybody stands up front. And we call that the founders agreements. And I put up on this slide kind of what the basic things that does, and I'll cover each one separately. But that's sort of the first thing we deal with when we help companies get started. So if you go to the next slide, please. So first thing founders agreement does is say, all right, what is everybody bringing to the table as far as setting up this company? So some people provide cash, some people provide services, either services going forward or past services. Some people provide property, such as intellectual property. But the founders agreement spells out who brings what to the table and how is the ownership structured. If you have three parties and they're all bringing equal amounts, then they're all 1/3 owners. And they typically have just basic common equity. You probably have heard the term preferred equity. I'll cover that a little bit more detail later, but preferred equity typically only arises once you get outside investors. And what happens is, as investors come in, they want to get an equity structure that's preferred to common, and it's preferred in a number of areas. Could be liquidity, voting, or dividends. So what happens if there's a liquidation is the preferred typically gets paid first. The preferred might have a dividend right, which is like interest on a note. Could also have a superior voting structure. But when you're first getting the company set up, you typically just issue common shares. And the founders agreement says, here's what everybody owns and here's how much we own. You sometimes set aside some amount for an equity plan, which I'll cover in more detail later, but up front, you need to specify sort of what everybody owns. So if you go to the next slide, second thing the founders agreement does is talks about transfer restrictions. So if I go into a partnership or I go set up a company with Ala, we probably don't want to have somebody else come into the company and become a partner. So we put in the founders agreement that neither one of us can transfer our shares without going through a right of first refusal process. Sometimes we allow for certain estate planning transfers. If someone were to die, you can transfer to your estate. But for basic transfers, we say that if you want to transfer, if I want to transfer my shares, I have to give her notice, have to say who the transferee is, what the terms of the transfer are, and then typically the company, our company, would have a right to match that offer. And if for some reason the company can't match it, then she would have the right to match it second. The idea being that you want to keep the equity within the original founders group. And if one person leaves, you end up, instead of having 3 people, you have 2 people. So if you go to the next slide, please. Next thing the founders agreement does is talks about what if somebody leaves. It's very common when you have more than a couple of people that over the lifetime of a company, someone will decide, I want to do something else. I've got another job. I've got another opportunity. I just want to leave this company. So you could say, all right, well, you just leave the company and you keep your ownership of your shares. Most companies like to say, well, we don't really want a non-participant to own those shares. So we want to buy those back. And so the founders agreement can have those buyback provisions. And it can be, you can put in there kind of whatever you want. You can put in a formula that's based upon some sort of revenues or earnings calculation. Now, if the company doesn't have earnings, that's hard to do. So sometimes you just do a fair market value assessment, and maybe you have an outside valuation firm do it. That's also expensive. It could be expensive. So you can just put in the agreement whatever you want the terms to be. But if someone leaves, you'd like to be able to buy their shares back. And you can typically say, we'll buy them back within a certain period of time after they leave, or you could structure it in some sort of note feature where they get paid back over 3 to 4 years. The second thing to think about is what if the person leaves sort of on bad terms? When you think about it, if someone just leaves for another opportunity, that's one thing. If they leave because they've done something that could give rise to cause, such as breaching an agreement, committing some act that puts the company in a bad light, you may want to have different provisions in that scenario. Certainly like a lower price or some sort of penalty for that situation where the person leaves. So you want to specify in the founders agreement what happens in the termination scenario. Now, if you go to the next slide, please. Well, the fourth thing the founders agreement does is talks about how are we going to govern the company generally. And if you don't, in the absence of a provision on governance, most states just say a majority of the shares can vote on a matter. What we oftentimes put in founders agreements is, well, there's certain things that are so important to the company that we want to have a higher percentage than that. So if there's 3 people and 2 people decide to do something, they can do it without the third coming along. So in that scenario, we might say we should have a supermajority provision being 75% of the shares. So that in that scenario, it effectively has to be unanimous because any one of the 3 people can block the action. And as you get bigger and more shares, you probably want to make sure that not one person can block it, but you need to have a significant, supermajority for certain items. So types of things that would be covered by this would be changing the line of business, bringing in new partners, investing in other companies, selling this company, issuing equity under general terms or equity plans. Those types of things typically would be covered by the supermajority provision. You also want to think about, we're going to have a board of directors likely. So most companies have either a board of managers for LLCs or a board of directors for corporations. And they kind of handle sort of day-to-day decisions that are outside the scope of just, things that the officers can do without board approval. So in the founders agreement, you specify how many board members we're going to have. Does each individual, at least each founder, get to choose one board member? And then do you have outsiders? You can put all that in the board provisions and make sure that they are agreed upon up front. And then if a person leaves, you can say that they no longer have their board seat or the board designation opportunity. So if you go to the next slide, please. So the last main thing the founders agreement does is cover what happens when the company is liquidated. Now, it can be liquidated because the company's not doing well, or it could be liquidated in the sense of the company has basically been sold or has sold its assets and now has a chunk of cash to distribute. So the founders agreement establishes how liquidation decisions are determined, who handles the liquidation process. For example, you got to eventually pay your debts. If you have leases, you got to terminate the lease. You got to sell real estate potentially. And then what happens to kind of the distributions and how they are distributed. Now, if you have preferred stock, as I mentioned, there would probably be some scenarios where the preferred would get paid first, depending on how it's structured. And then you would have the rest would go to common. When you do have preferred stock, if you have multiple rounds of financing, it's common to have various series of preferred. So you might have, let's say, 3 series of preferred: Series A, Series B, and Series C. And what's typical is each round of preferred gets a new series, and each one is preferred to the prior. So in that scenario, typically the C would get paid first, the B would then get paid, and then the A would get paid before the common. And depending on the value of the company, you run some calculations to see if how much each person gets. If it's convertible preferred and the valuation is high enough, then it's possible the preferred gets converted, and then everybody shares in that, in the total pot. So if you go to the next slide, please. That's kind of a briefing on founders agreements. Like I said, that's the first thing we cover with startups, and it's important to get those in place. And I should mention that what I'm talking about is relatively complicated. We do have packages for startups where we will put these together for a fixed fee, depending on what the business is. And so I'm happy to talk with people about that if needed. Second agreement is an NDA. Most people know what NDAs are, but we oftentimes help clients put those together. The key to an NDA, I think, really is just making sure that it's limited enough in scope and time as to be enforceable. So you typically do not want to have an NDA that's unlimited in as far as the time period. We would normally go out 2 years at the most, oftentimes 1 year. And the theory behind that is that information generally in today's age becomes non-confidential very quickly. And so the shorter you can make it, the better. The agreement can be either one way or two way. Oftentimes we do 2 ways, meaning that if I'm if I have a company and I'm giving information to Ala, we each agree that the information, and she gives me some information, each of the information we give to each other is confidential, and we agreed to respect it that way. Now, one thing that's interesting under NDAs is a trade secret concept. A lot of people know what trade secrets are, but it's a specifically defined term into the law. And it's really something that has independent economic value by not being known, not being disclosed publicly, and you have to take reasonable steps to keep it secret. So the classic example that people have used over the years is the formula for the syrup in Coca-Cola. That's a trade secret, and it's been protected by Coke ever since they came up with it years ago and they protect it by only giving it to like 1 or 2 people in the company, and they lock it away. So it's never been publicly disclosed. Nobody really even knows what it is, but it has a certain formula that's not found in other sodas. So if you go to the next slide, please. So the next category agreements, I will just call IP agreements, and I'll talk about two different nuances of that. So the first is intellectual property agreements as it relates to employee and consultants. And so what these are, and these can be combined in, with the service agreement, which I'll talk about in a minute. But if you're going to have people working with your company and they're going to be working on intellectual property, it's good to have them acknowledge up front that anything they do for you while they're working for the company is company property. So they assign basically all rights to the technology that they're working on. Now, there can be certain retained rights. If, for example, they're only doing certain aspects of it, they can retain some of the IP for other rights, but it's really important to spell that out in the agreement so that it's clear, because if you have people come in doing due diligence on you later, investors, they want to make sure you have clear title to the intellectual property you develop. So you typically would start out with some intellectual property you either have developed or got or had from a license, and then you expand it. And you want to make sure that everybody you're working with has assigned that over. So we work with assignment of inventions agreements for people. And the other thing to specify is, are they employees or consultants? If they're just regular employees, they may be, state law probably has some provisions which protect you, but you still want to make sure that you have in the agreement that they've assigned their rights over to you. Consultants, it's not as clear, because if they're a consultant, you don't have the same employment relationship with them going forward. I would also say that we've seen situations where people use consultants sort of on a full-time basis, and that's not the favorite approach. The federal government came out against that several years ago. If you're using someone on a full-time basis and they're not really doing any other work outside of what they're doing for your company, they should really be employees, not consultants. So if you go to the next slide, please. I will now talk about IP licenses, and this is where you get into negotiating with a third party, either a research institution like Maryland, or sometimes it's a strategic partner that has its own intellectual property. So before I get into IP, into the license itself, I just wanted to mention option to license, which is becoming really popular with institutions. So what they do is, instead of signing the full license agreement up front, they will give the company the option to license technology. And the option is requires your company normally to meet certain milestones, certain usually scientific milestones, but there can also be some financial milestones. But if you meet those and you prove out the technology, then you can exercise the right to license the technology from the university. And the reason I think why options are more popular now is because institutions are saying, and rather have, if the technology turns out to not be what we think, or not be something you can build a company around, instead of going through the process of doing the full license, we'll just give them an option. And if they never exercise the option, then we just go and license the technology to somebody else. But if you get to the point of doing a license, then obviously there's things you need to specify in there. So for example, what is the intellectual property that's being licensed? Does it include a specific patent, a patent application? What do you do with improvements and know-how that's associated with that? You want to cover that in the license agreement, either by including it or not including it. Is it exclusive or non-exclusive? Most times you want to have an exclusive license, at least for a specific field. So whatever the field of use that your company is going to be using that technology on, it would be nice to get exclusive, because if you're going to have investors, they're going to want to make sure that someone else can't use it sort of in that field. It's typical for institutions to keep back the right to use it for research or non-commercialization purposes. And so that would be a standard term you'd see in a license agreement with the university, but you want to specify that. And then what are the economic terms? Normally, there's an upfront payment required to do the license. Now, some universities, including I think Maryland, will say, we won't necessarily make you pay the full cash amount. You can give us some equity in exchange for that. But there is that upfront payment, and then there's typically ongoing royalty payments. And then the license agreement will also cover things like, what happens if you sub-license it to a third party, or someone else wants to use it. And then what happens if your company develops technology that expands on this. So that's probably, aside from the founders agreement, that's maybe the second most important agreement, or maybe the most important agreement that your company's going to have if you're going to be working in the technology sector. So if you go to the next slide, please. So service agreements, and they could be employment agreement or consultant agreements, and they could cover the assignment of inventions I mentioned earlier in one agreement. But it's oftentimes wise to have an agreement in place with people that are going to be working with you to cover what the scope of their duties are, who they're, what are they doing, who are they working for, what's their compensation. I mean, that's sort of obvious. They get a salary typically, they would get benefits, but then is there an equity component to it? And I'll talk about equity in a minute, but most startups we deal with don't have a ton of cash, so they're working a little bit at a disadvantage because they can't necessarily pay a cash salary to people to the same level that they could get to, with a larger company. But they offset that by providing them some equity, which could have a higher value and likely would have a higher value if the company does really well. The other thing you want to specify in these is if the person's going to be doing other activities, either for another company or for research institutions, you should specify that so that it's clear that they're doing those other things on behalf of some other third party and not for the company. So if you turn to the next slide, please. So let me talk briefly about restrictive covenants, and you can also include this in the service agreement, or it can be in a separate agreement. So most people, when they think about restrictive covenants, think about the standard non-compete, which means if I leave my company, I can't compete with the company for some period of time. And sometimes it can be a specified territory, it can be worldwide. The key to a non-compete is to make it as narrow as possible to be enforceable, both in geographic scope and in time. I see a lot of non-competes that are drafted as, they're clearly too broad. And there's been a movement to kind of outlaw non-competes. There's a number of states that have already outlawed non-competes, California being one of them, where they just will not allow you to enforce them. And you may have read that the FTC came out with a guidance of just trying to outlaw non-competes federally. That was basically put on hold. I think under the current administration, that might be on hold for some time, but they're coming out of favor in part because they've been, I think, abused over the years. The case that really started this problem was Jimmy John's, which is a submarine shop, was requiring all their employees to sign non-competes. And when you think about it, that's kind of absurd because they would force one of the people that were making like a turkey sub to not be able to work, Subway down the street. What knowledge did they really gain about turkey subs that would be problematic to Jimmy John's? So that started the whole process of kind of making non-competes in disfavor. But there are other restrictive covenants though that are less likely to be kind of compromised, and that's non-solicitation and non-disparagement. And those can be as effective. So non-solicitation is basically saying you can't contact the people that the company worked with and that you worked with while working for the company for a period of time. Those certainly are enforceable and likely will remain enforceable. And non-disparagement is what it sounds like. You just can't make negative statements about the company. And so those things are typically things that we do put in documents, and we oftentimes will put in non-competes, but we want to make sure, like I said, that they're very narrow. And as far as a time period, typically we don't like to go out, certainly no longer than 2 years, and most cases no longer than 1 year for these, because as I said, courts are not generally not in favor of these. They tend to restrict someone's ability to get out of their jobs, and they don't like that. Now, if you're going to pay someone severance, which is not typical for startups, but if you are paying severance, it's very common to have at least the non-compete period run during the severance period. If you give someone 6 months severance, you could have them not compete for 6 months. So if you go to the next slide, please. So let me talk about equity plans, because I mentioned earlier that that's one way to compensate your employees and consultants beyond their salary. So this is a very common document that we use, and we typically do it by creating a master plan that the company adopts. And the plan is typically administered by a board of directors or some committee of the board. And it's very broad, it allows the company to issue restricted stock, options, or in the case of LLCs, profits interest. And the plan says, who gets what, who awards what, and what are the terms of the grant. The way equity plans work best, I think, is to have them have some sort of vesting feature associated with it. And the reason the vesting works is because you incentivize a person to stay with the company. We see vesting periods that run typically somewhere between 3 and 5 years. So you're really giving someone an incentive to stay with the company while their awards vest. And you could do it so it just kind of vests over time. Over the 3-year period, you could have what's called cliff vesting, where after a certain period of time, a chunk vests, and then after another period of time, another chunk vests. You could also do it based upon some performance hurdles, meaning if the company meets certain scientific milestones or financial milestones, a different group of options vest. But the idea behind these is that you want to give someone compensation beyond their salary that eventually will be worth a lot of money to them if the company does well, that'll keep them around and incentivize them to stay. There are some tax nuances with these, and so it's a little bit beyond this talk. Happy to talk about with people later on that, but just make sure you think about the tax consequences. But these typically work really well when the company is sold, because if the company is sold, you usually say that options vest entirely, and people end up getting a nice chunk of cash. And it's something they can, they're not planning for, they're not typically budgeting for, but it ends up being a nice bonus, and they feel good about their work with the company. So these are things and you can give options to other outside consultants, to board members, so they work pretty well in that context. So if you turn to the next slide, please. So I want to touch on website documents. Most companies we deal with, or a lot of companies we deal with, sell products and services on the web. And so what they deal with is, all right, how do I make sure that the person that the company that's buying the products are, they've properly read all my disclosures. So you put the terms and conditions on the website. The acceptance process is on there. If there's certain warranties or disclaimers that you want to make, that should be clear. And there's certain ways to do that to make sure that the person acknowledges they've read that. We help people navigate through that. It's somewhat more complicated than it seems, but we certainly have worked with companies on the nuances of that. And the other thing I would say is, if most companies use third-party payment services, you want to make sure that those are set up correctly, so that you're not, when people are inputting their payment information, it's really, you don't really have access to a lot of that information, because that way you protect yourself. If somehow your company is hacked, you don't really have access to someone's credit card numbers and things like that. That's all done with the third-party payment process. So if you turn to the next slide, please. The last sort of main topic I wanted to talk about is kind of investment documents, because we deal with those a lot. Let me start with the process that we typically see with startups, and that is, before you get to actually having a full-blown set of investment documents, you oftentimes have investors say, well, we'll just buy either a convertible note or a SAFE standing for simple agreement for future equity. And they're basically similar, and I'll talk about each briefly, but what it is an obligation. They're paying money to the company, and then they're getting back an instrument. That instrument, whether it's a note or a SAFE, typically allows them to convert that amount of money into the next round of financing. The reason they use notes and SAFEs is because it's hard to value a startup when they're coming in to the process. And so the SAFE and note really allows you to defer that discussion till a later time when you have outside investors coming in. And the way they typically work is, if you get equity at what's called the equity financing threshold, that could be, let's say, $500,000, $1 million, then at that time, the holder of the note or the SAFE has the right to convert their instrument into equity that's sold in that round. That typically both notes and safes have a discount feature associated to it. So the way that works is if you're selling, let's say, $1 million of stock at $10 a share, the holders of the notes and in safes would be able to convert that effectively, let's say $8 a share. That would be a 20% discount. So they'd get more shares for their investment than they would have had they just invested that same money at the time of the equity investment. And when you think about that, makes sense because they're coming to the table up front, taking the risk when the company isn't worth much and may not be worth much. They're putting money into the company. So that's kind of how safes work. They also sometimes have what's called a valuation cap. And in my example, if the valuation cap was $5 million and you're selling at a $10 million valuation, then they would basically be able to convert as though the company value was 5 million. So they would get quite a few more shares for their note and safe. The main difference between a note and a safe is the note is an actual debt instrument that is higher in the capital structure. If the company were to dissolve, someone has an unsecured note with the company. A safe is just basically an agreement with the company to issue equity in the future. So now let's just say you get to the point of actually issuing equity in an equity round. You would have a series of documents, and we help navigate this process. There's usually a set of up to 4 or 5 documents that are used in any sort of investment like that. First, there's the basic investment agreement. And what that is that sets forth what the investors are investing, how much they're investing, and what equity they're getting back for it. Is it just common? Is it preferred? Is it a series of preferred? Those are all spelled out in the equity agreement. The equity investment agreement would also typically have the company make certain warranties and representations about the company. So investors typically do some due diligence, which is investigation about the company. And when they're ready to make an investment, they want to have the investment agreement where the company basically confirms what was said in the due diligence. Similarly, the investors would also be making representations in the investment document. So you want to have investors that are usually accredited investors, accredited meaning someone who's got at least $1 million of net worth and or a certain level of salary, typically $300,000. And the reason for offering to accredited only, and I would say most people in the startup space are accredited investors, but is that the securities laws have less restrictions on what you can offer to accredited investors. So you typically want to have them say they're accredited. They understand that what they're investing in is a private company without a long operating history. It's a risky investment. They're able to withstand the complete loss of their investment. There's certain standard representations that the investors would make. So that's kind of the main document you get. There's also a series of other documents. Most investors use what are called the NVCA documents. NVCA stands for the National Venture Capital Association. That's a trade association of venture capitalists who have created documents that they use for investments. They're pretty cumbersome, but if you've worked with them a lot, like we have, they're kind of standard forms, and you get used to them. And as long as investors are using those documents, it's pretty easy to navigate those. Those include right of first refusal and co-sale agreement, a voting agreement, and investor rights agreement. And then the third thing you typically would have to do when you get outside investors is you'd have to amend your articles of incorporation, because oftentimes you're creating a new class of preferred stock, and the preferred stock typically is created in the articles. So you'd be filing that, and there'd be a series of provisions that talk about what the preferences are in the for that preferred stock. So all those get signed at the time you're completing your equity round. Typically, any notes and safes you have are converted at that time. So you have somewhat of a straightforward capital structure. Now, it can still be complex because you could have a series of preferred, but you could you can prepare a cap table for people that is relatively understandable. There are certain third parties that have, like for example, Carta is one of them that will, for a fee, keep track of all this stuff for you. So you give them You give them all your equity documents, you give them your options, your restricted stock, and they create a portal for your company. And then investors can also use that to kind of log in to see where things stand, how much they own of the company, that type of thing. So when you get a little bit more sophisticated and have a little more cash, you may consider using one of those third-party services as well. And then sort of the last thing, I don't have a slide for this, but if everything goes well, you eventually have a liquidity event, a sales transaction. Obviously, at that point, you're in sort of the regular M&A environment where we're dealing with outside investors, either strategic partners or private equity groups or other strategic companies that are willing to buy you. And at that point, all of these documents then are used to figure out how much everybody gets of the final pot. The other thing I would mention is once you get to the point of getting these investment documents in place, oftentimes that original founders agreement that I mentioned sort of toward the beginning would get either superseded or amended. Oftentimes it just gets eliminated because these documents serve as kind of your investment and your documents going forward. So I know I covered a lot kind of quickly, but I do have time for questions here, and that's kind of the end of my formal presentation. Happy to talk about anything on what I just touched on.
Thank you, Mark. This has been a fantastic, very thorough presentation about all important topics. So at this point, if anybody has a question, you can either type them up or you can raise your hand and I can unmute your mic. You can ask your question that way. In the meantime, I wanted to ask you about non-competes. Are they still legal in the state of Maryland? And would you
I should check on that. I'm not positive on that but I can I'll check. I believe they are. I don't think Maryland is one of the states where they've been outlawed yet. But as I mentioned, there was a movement to kind of outlaw them federally. So I think that'll be kind of put on hold. But I think you'll see, and they won't be outlawed for everybody. Certainly like senior executives. Like if you're a senior executive, GE, they don't want you to leave and go to another company. But I think that they will try to put their arms around sort of just general non-compete that kind of are signed by rank and file, because those were the ones that were the most problematic, I think.
Okay. Yeah.
And the Jimmy John's example is a good one. Like, why would you care whether someone left Jimmy John's to go to Subway? I mean, the fact that they required people to sign that was kind of interesting. The other thing about non-competes is you need to have, since it's an agreement with somebody, you need to have consideration for signing those. So you can make it part of your original employment package, but if they're already employees, you've got to pay them something for it, whether it's cash or giving them options or something. You can't just make them sign it because you want them to sign it. So
I think many people don't realize that they can
yeah,
actually ask to
yeah,
be paid something in
right.
exchange for that. Yeah.
It doesn't have to be a lot of money, but it has to be some. I mean, if you're at a company and all of a sudden they just make you sign a non-compete, I would say, well, what are you compensating me for signing this? Because this is like a new agreement that I'm creating restrictions on myself for.
Yeah. Thank you for that. And in terms of picking LLC or C Corp, are there any advantages? So say, for example, if it's a high, if it's a high growth startup intending to grow real quick, should they go ahead and pick the C Corp right away, or is there any advantage to pick the LLC?
I think if it's a high growth company that they think they're going to get outside investors pretty quickly, they should just start as a C corp, because the double tax doesn't really come into play until you make money. I mean, double tax on zero is still zero, right? So I think you would probably just bite the bullet and say, let's just become a C corporation because we know that's where we're going to be, and investors expect to see that. And the documentation, if you don't, the documentation is similar to actually creating both companies, so there's not a big cost savings one way or the other on that. But I think the C corporation is what we see most typically when it's going to be one of those faster growing startups.
Yeah. Here's a question just came in. Do you need to have a Delaware address to register your business in Delaware?
No. but that's a good question. So if you are, well, let's put it this way, you do need to have enough, you do need to have a registered address, but you can, I believe you can have it, you can use one of what's called like a third-party service for that, and they just charge a small amount of money. There's a bunch of them where you have to have like a registered agent there. And so you could use one of the third-party services, and we have deals with these third-party services where they charge us, I think it's like $50 a year for that service or something. So you do need to designate that, but when you use a third-party service, it works really well because they take everything in and they send it to you right away, and you never risk that you're missing something in the notice. And the reason they want you to have a registered agent is if you're a Delaware company or a Maryland company, you need a registered agent wherever you get set up. Is because they want to have an official place where someone can contact you if there's an issue, whether it's a lawsuit or a claim or something. If you don't have any sort of street address, you can't do that.
Yeah, thank you. So if I am a resident of Maryland, should I just use my home address as a registered? Can I be my own registered agent?
Yeah,
Or should I?
you could do that. The other thing to think about is sometimes you need to, if you set up and if your company's going to be headquartered in Maryland and you set up as a Delaware company, you might have to register what's called as a foreign entity in Maryland. That's just a second filing, which is not a big deal, but you typically would do that if you're actually going to have like a physical office there, if you're going to start hiring employees. If you actually have an office in Maryland and a Delaware corporation, then you would register in the state um, as a foreign company. So like, for example, our law firm, we're headquartered in Wisconsin, but we're registered to do business in all the states where we have official offices. And someone keeps track, you just have to do it based on annual report in each of those states. Just a way for the state to make a little bit more money off you down the road. But it's not a huge amount of money to file that filing everywhere.
Mhm. And so if companies are registered in more than one state, are they also obligated to pay taxes in those states, or is it just the annual fee?
It's really the annual fee that the taxes, talking about income taxes gets a little more complicated. So that it depends on how, that's a hard question to answer. You might have some tax liability in those other states, but it depends on, like, does all your revenue come into the state? Like if you're basically shipping product or services just from one location, typically you would only have to pay in that location. So, but if you start having satellite facilities where you're shipping products from those facilities, you probably have to pay some tax there. So for example, like a GM, let's say, that has a plant in Ohio, I'm sure they probably pay Ohio tax for the vehicles that they ship out of Ohio, things like that. So
Yeah.
that's a
And
nice problem to have because that means you've got enough revenue in various states that you can actually, and most, any accounting firm or a law firm could help you navigate that process, but that means you've got enough money coming in that it's worth considering the tax. So
yeah. And is registering company in Delaware still have the big advantage over, say, for example, registering it in Maryland or some other state?
not as much as it used to. I think Delaware originally had, they were like the first state to adopt the sort of the general corporation law, but most states have followed with something that's very similar to that. So there's the advantage of going to Delaware is not as big as it used to be, I would say.
Mhm.
The one advantage is that if you get outside investors, and you say you're a Delaware entity, that sort of just answers, they don't have to, well, if you're a Maryland company, they say, okay, I got to maybe make sure that there's nothing in Maryland that's different than Delaware. They know what Delaware is, and so that just answers one question that they might have.
Got it. So it just makes it easier for
Yeah.
investors to make that decision. Got it. Does anybody else have any other questions? You can either raise your hand or type it up in the Q&A or even chat as well. That works as well, or any comments from Mark. So I will be posting this video on our Startup UMD YouTube channel. So for those of you who couldn't come in, you can watch it there. I can also share Mark's slides. You could shoot me an email, and I'd be happy to share a PDF of the slides. And Mark, you shared your contact info, right?
It's
Anybody else?
yeah, it's part of it's in the last slide. If they get the slide, yeah, it's in there, and happy to answer questions offline with people. I know what I covered is a lot and it seems maybe overwhelming, but we try to help navigate this to make it a little bit more simple for people. And you're not going to necessarily need all the agreements I covered right away, but eventually, if your company does well, hopefully you'll need those down the road. So
Yeah, absolutely. Absolutely. Well, if there are no more questions, or if you think of them, you can shoot them to me or Mark later. But if no more questions, I'd like to thank Mark for such a fantastic nuts and bolts presentation. And thank you for all of the explanations. I hope that it made things clear for many people here. And we'll hope to have you again, maybe for another session on another topic. But
happy to do that. Yep.
yeah, thank you so much to everyone who logged in and stayed with us. Thank you.
Have a good day, everybody.
Thanks. Bye bye.
Bye.